Chapter 3. What the purchaser buys, estate and interests in land. Which of the following is not a characteristic of a fee simple estate? It is a leasehold interest. There is a large Olympic-sized pool in the backyard of the home Margaret owns in Coquitlam. Each week in the summer, a worker from a pool maintenance company comes in and cleans the pool. Usually when he is cleaning the pool, the backwash runs over and chlorinated water leaks down on the garden of the neighbor below, killing the flowers. Both Margaret and the worker from the pool company are aware of what is happening. This would be considered which of the following? A private nuisance. Which of the following statements about the fee simple estate is true? An owner of a fee simple estate has the right to sell, rent, or lease the estate. Gita was out walking and saw a for sale sign on the lawn of a house called Green Acres. She decided to ask the owners about the price of the property. Unknown to Gita, the owners of Green Acres were away on a long vacation in Jamaica. As Gita was walking across the lawn of Green Acres, a long branch from an old tree that grew in a neighboring yard fell down and hit her. As a result, Gita broke her leg and could not return to work for 2 months. Which of the following statements is true? The owners of Green Acres may be liable to Gita even though they were not home at the time of the accident. The term fee simple indicates something less than absolute ownership of land. A limitation or restriction placed upon the use of one person's land for the benefit of another is called a restrictive covenant. The duty of care imposed by the Occupier's Liability Act does not apply to which of the following options? Risks willingly accepted by a person as their own risks. Ownership of land in British Columbia includes not only the surface of the land, but also objects affixed to the land for the purpose of improving the land. Which one of the following actions would constitute a trespass? John is on a museum tour and wanders off through a door stating no admittance. Karen's neighbor, Jack, is a gas barbecue enthusiast who cooks 2 meals a day, 7 days a week, on his outdoor gas barbecue. As a result, the smoke and fumes are carried onto Karen's property. The barbecue smoke has discolored Karen's dining room curtains and killed her shrubs. Jack may be liable to Karen for private nuisance, and Karen may seek an injunction to prevent Jack from continuing the nuisance. Hurston, the head of production at XYZ Preservatives Ltd., has been ordered by the company's president in Toronto to vent some gases that have been stored in a pressure chamber at the Vancouver plant. Although the president knows that the gas is highly toxic, Hurston has been assured by the president that the gas is totally harmless and will quickly dissipate when released. Unfortunately, having escaped from the pressure chamber, the gas drifts in a dense cloud over Ralph's neighboring apple orchard and destroys the apple crop. Which one of the following is true? Ralph will probably succeed in a claim against XYZ based on negligence. Mary registers a document, given to her by John, in the Land Title Office. The document states that I, John, grant to Mary and her heirs, assigns, executors, and administrators a right-of-way for persons and vehicles along and upon the easterly 30 feet of the southerly 64 feet of Lot 1, Plan 910, in order to give access to Mary's property, Lot 2, Plan 910. The interest granted is an easement. There were 3 categories of waste at common law with respect to real property. Which one of the following is not one of those categories? Equitable. Which of the following statements about fee simple estate is true? The term fee simple indicates an estate that can be inherited without qualification. Which of the following is an interest in land that can be valued? 1. An easement or right-of-way. 2. Building scheme. 3. Leasehold. Which of the following statements about easements is true? An implied easement may result if the intention of the property owners has not been sufficiently explicit. Anton holds a life estate per autre vivant based on Bentley's life. Charles has the remainder interest in fee simple. Anton's interest will terminate when Bentley dies. Robert is dying of a terminal illness. He therefore arranges for his wife Elaine to have a life estate with respect to his ancestral home with the fee simple to go to his daughter Whitney once Elaine dies. Whitney's interest is that of a remainder man. Ownership of land includes not only the surface of the land, but also which of the following options? The column of airspace above it insofar as the owner can make effective use of it. Mary and John own a piece of real property as joint tenants. Which of the following is false? Mary and John can have different interests in the property. Which one of the following is not essential in order to constitute a restrictive covenant in law? It must be positive in nature. A visitor enters an apartment building to visit a tenant. As he enters the lobby, the skylight above collapses, injuring the visitor. If the visitor decides to sue the owner and/or building manager, what cause of action will the visitor likely use? Occupier's liability. Akiko Yamada vacated the property she had just sold, taking all her household furniture. Assuming she has taken each of the following items, which items must Akiko replace? Assume that none of the following items have been dealt with specifically in the contract of purchase and sale. Wall-to-wall carpeting from the den, which had been attached to a tack strip that, in turn, was attached to the hardwood floor. Which of the following statements about fixtures and chattels is false? Where an item has been affixed for the enhancement of the use of the premises, that is evidence the item is a chattel. Which of the following statements about fixtures and chattels is false? A seller of real property has the right to detach and remove any fixture after entering the contract of purchase and sale, if they so desire. Eugene and Lenore visited Green Maple Tree Farms. The property is owned and operated by Rodney. Trees kept for sale are placed in holes in the ground, with their roots encased in burlap. The holes are not filled in when a tree is removed, but are located in a grid pattern, which is apparent to any viewer. Signs are located at the beginning and end of every row of trees warning customers to watch for and avoid open holes. Eugene and Lenore walked among the rows of trees while selecting a tree for their purchase. Eugene and Lenore noticed an open hole, approximately 3 feet in diameter. Lenore walked around the hole and Eugene attempted to step across the hole. Eugene fell into the hole and fractured his leg. Shortly after this event, Lenore tripped over a green garden hose lying unseen in the grass between the rows of trees, which was left by Rodney earlier in the day. Lenore broke her arm in her fall. Which of the following statements is true? Eugene will probably not recover any damages in a lawsuit against Rodney because he breached his duty to take reasonable care for his own safety. He was the author of his own harm. Ethan visited a used car lot, owned and operated by Clara. The lot contains a variety of used cars, in addition to a marked-off area where Clara keeps a variety of car parts. There are large signs around the marked-off area, warning customers not to enter the area without the presence of an employee. Ethan, while walking around the lot, noticed a set of vintage car wheels in the marked-off area. Disregarding the signage, Ethan entered the area to get a closer look at the wheels. Unfortunately, Ethan stepped on a small engine part that was lying on the ground and slipped and broke his ankle. Which of the following statements is true? If Ethan was an infant, he would likely be owed a higher duty of care than an adult because of an infant's relative inability to appreciate the danger presented by marked-off areas in a used car lot. Which of the following statements about the law in British Columbia governing occupiers' liability is false? The language of the Occupiers' Liability Act expressly preserves the common law distinction between the different types of visitors. A life tenancy has been granted to Avon without liability for waste. For which of the following actions would Avon incur liability to the remainder man? Destruction and removal of all the buildings from the land out of spite to the remainder man. Which one of the following is not a remedy available for a private nuisance? Specific performance. Which of the following statements regarding joint tenancy is false? Where two legally married spouses own property as tenants in common and one of them dies, the other becomes the owner of the whole interest. Mr. and Mrs. Tom Jones and Ashraf Menzies have a signed contract of purchase and sale for a triplex owned by Alan Sinclair. Mr. and Mrs. Jones have agreed to pay $100,000 each and Ashraf has agreed to pay the balance of $50,000. They would like their ownership registered as a joint tenancy. Which one of the following statements is true? If their interest is registered as a joint tenancy, Tom, Mrs. Jones, and Ashraf will each own an undivided interest in the triplex. Which one of the following actions would constitute trespass to land? 1. The crossing of another person's property by mistake. 2. The deliberate crossing of another person's property. 3. The throwing of an item upon another person's property. Which of the following is a basic requirement for an easement in British Columbia? The easement must be capable of forming the subject matter of a grant. Which of the following is not one of the three main classifications of interests in land that are less than estates? Licenses. Which of the following options best completes this sentence? A private nuisance involves some use of a person's own property that interferes with the use and enjoyment of, or causes damage to, the property of another. Where two neighboring landowners contract to prevent one of them from putting their land to a certain use, they are said to have created a restrictive covenant. Which of the following statements about restrictive covenants is false? The covenanter must retain the restricted property, as any subsequent buyer will not be a party to the original contract. Cornelius gave a life tenancy to Rule, which did not expressly state anything about Rule's liability for waste. Rule will not be liable to the remainder man for permissive waste. Which of the following statements regarding profits à prendre is true? The right to fish on another's land is an example of a profit à prendre. A life tenancy has been granted to Avon without impeachment for waste. For which of the following actions would Avon be liable? 1. Putting new shingles on the garage roof. 2. Allowing the tool shed to deteriorate and collapse. 3. Cutting down some trees on the property. The correct answer, Avon would not be liable in any of the above situations. Howard slipped on a patch of ice and broke his ankle when walking up Laura's driveway to deliver a package. As a result, Howard suffered loss of wages until he recovered. Which of the following statements is true? If Laura had taken reasonable and responsible precautions, such as applying sand or salt regularly to prevent ice building up on the driveway, she will likely not be liable to Howard under the Occupiers Liability Act. Which of the following situations are consistent with the existence of a joint tenancy under current British Columbia law? Herman was a co-owner of Blue Acre. When Herman died, the surviving co-owners of Blue Acre automatically became its only co-owners. Bert and Ernie owned, as joint tenants, a revenue-producing property, which was leased to Oscar. Ernie died, leaving a will, which gave his interest in the property to Grover. Grover is now demanding one half of the rent paid by Oscar. Bert refuses this request. Which of the following statements is true? No interest in the property could be transferred to Grover via Ernie's will because the entirety of Ernie's interest in the property passed to Bert when Ernie died. The greatest bundle of rights and responsibilities that an individual can hold with respect to land is a fee simple interest. Which of the following statements concerning restrictive covenants is false? The covenant must be worded in positive terms. Mimi was house-sitting for her friends Tom and Lizzie while they were on a 3-month photo safari in Africa. The front porch was damaged in a freak storm that caused a tree to fall and smash the bottom 2 steps. Mimi didn't have the money to hire a carpenter to repair the stairs, so she attached a large sign to the bottom of the steps reading, "Danger Keep OFF." Dave, an out-of-work handyman who could not read English, was walking from house to house in the neighborhood looking for casual work. He entered Tom and Lizzie's property, and not understanding the sign started up the steps to the front door. Dave landed on the damaged step, and the weight of his body was more than the step could stand. He broke his leg in 2 places, and having no insurance, has run up $3,750 in medical bills. Dave now intends to begin a lawsuit. Which of the following statements is false? Dave will be unsuccessful in his lawsuit because he willingly accepted the risk of injury when he walked up the broken steps. Which of the following is not normally included in the concept of real property? Movable objects such as furniture. A building scheme is a special example of a group of restrictive covenants attaching to 2 or more lots within a particular development plan. Which of the following statements concerning building schemes is false? Buyers must negotiate any exemptions from the application of the building scheme individually prior to purchase. Which of the following options best describes a building scheme? It is a set of restrictions on a development used to maintain uniformity. The owner of an interest in real property that is located in British Columbia always has common law rights as modified by legislation. Mary and John own a piece of real property as joint tenants. Which of the following is true? Mary and John must each have an undivided interest in the whole of the property. The fact that a joint tenant's interest does not pass to a personal representative on death is referred to as the right of survivorship. In British Columbia, there are 3 basic requirements for an easement. Which one of the following is not a requirement? The dominant and servient tenements must be owned by different parties. Hurston, an employee of XYZ Preservatives Ltd., is in the habit of venting a cloud of highly toxic gas into the air at dusk every evening. Once it escapes, the cloud usually drifts over Ralph's apple orchard. Hurston's actions are strictly against company policy, but by venting the gas, Hurston saves time. Hurston is aware that the gas is highly toxic. Ralph has discovered that the emissions have destroyed his apple crop. Which one of the following statements is true? Ralph may be successful in a claim against XYZ based on the principle of private nuisance. In British Columbia, there are 3 basic requirements for an easement. Which one of the following is a requirement? The easement must be capable of forming the subject matter of a grant. Fletcher owns Lot 1, a rock-strewn beachfront property to which he had added 1 ton of white sand imported from Aruba. Anna, owner of Lot 2, is Fletcher's neighbor. Lot 2 has a tennis court located near the beach. On windy days, the fine white sand on Fletcher's property is carried by the wind onto Anna's property, where it coats the clay surface of the tennis court, making it very slippery and hazardous for anyone playing there. Anna has discussed this problem with Fletcher on several occasions, but he has not done anything to prevent the problem from continuing. Anna has been unable to use her tennis court for several months as a result of the sand accumulating on the property. Which of the following statements is true? This is likely an example of the tort of private nuisance.